Constitution. So what we are doing here is governed by the Constitution. That's why if you go to section 43 of the 1999 Constitution, it says that subject to the provisions of this Constitution, every citizen of Nigeria shall have the right to acquire, and own immovable property anywhere in Nigeria. You can be here and own a property in Nasarawa. That's why, let's bring it down. Most of us are not from Enugu State here, but they own properties here. They own properties in Ebonyi State, Imo State, Abia, or Calabar, anywhere. You are fully backed by the Constitution. You can do that. So, since the Constitution guarantees your acquisition of land in any part of Nigeria, you see that you will do it with your full chest. Now, let's just go to the specifics of title documents in real estate in Nigeria. They are normally called or tagged deed. That's why you see deed of assignment, deed of power of attorney, and the rest. Deed is a word that simply means something that is signed, sealed, and delivered. Something that is signed between us, we sealed it, and we delivered it to each other. Now, land title documents in Nigeria provide evidence of ownership, rights, and interests in land or property by virtue of the Land Use Act of 1978. Currently, by virtue of this act, all lands in this country, in every part of this country and in any state, is vested in the state governor, who holds it in trust for the people. Currently, there is nothing like freehold. If you can recollect yesterday, we did some type on rights in real estate. We mentioned freehold. Sorry?
Freehold and leasehold.
Thank you. So freehold is when you have the ownership, rights and interest in land in perpetuity. It's not being gathered. You are not being caged whatsoever. You have it for a lifetime. It's no longer in existence. Nobody can come out today and say that he has a land that will last forever. We are now being somewhat packaged. Our rights, interest, and ownership in land are now being confined rather to what we call long-term leasehold. That's why even if you have a certificate of occupancy, you see that it lasts for 99 years and you still go back and renew when it expires. Do you understand it? Before, you used to be, you have it till you die, your children or whoever that will inherit it from you will have it till him or her dies as well. But it's no longer in existence. Now, that's since 1978. The governor is now the trustee of all the whole lands in every state. What we have now is statutory right of occupancy. It's now the right of occupancy. It has to be confined by statute. You don't have it in perpetuity again. And the most you can get is 99 years. After 99 years, you come and renew. Now, there are different modes of transfer of title, ownership, and interest in real estate in Nigeria today. One of them is certificate of occupancy. That's one. Secondly is governor's consent. Two, we have deed of assignment. We have registered survey plan. We have accession and gazette. We have deed of mortgage. We have deed of power of attorney or deed of irrevocable power of attorney. We have, am I too fast?
Yes.
I'll take it over again. Different modes of transfer of ownership, rights, and interests in land today includes the following. Number one, certificate of occupancy. Number two, governor's consent. Number three, deed of assignment. Number four, registered survey plan. Number five, accession and gazettes. We also have deed of mortgage. We have deed of attorney. Sorry. We have of probate / letters of administration. Grants of probate / letters of administration. Yes, administration. They're together. You can put them / letters of administration. We have contract of sale agreements. We have deed of gifts. We have deed of partition. We have deed of lease. We have deed of sublease. So we are going to take them seriously. So number one is certificate of occupancy, which is in short C of O. As a realtor, you must have heard the word countless times. And now C of O. Does this land have C of O? From both prospect and clients. Now, what's the C of O? C of O is a document that is registered at the lands registry that connotes or that shows that the state government has taken cognizance of the present ownership of the land. That's the current owner of the land. The government knows the person and is with the data of the person. C of O is a document that is registered at the lands registry that connotes that the government or that shows that the government has taken cognizance of the current owner or holder of a right, ownership and possession of a particular plot or parcel of land. So the government now has taken note that you are the one that owns this place and they registered it for you and gave you a document. That's the C of O. Shows that government knows that this land somewhere here is owned by. It's been given for different purposes. You can have agricultural C of O and you can have residential C of O. And they do come with different duration. You can be issued with a C of O that will last for 99 years. You can be issued with a C of O that will last for 45 years, as the case may be. Now, if you noticed in the definition of the C of O, we just mentioned, I said it is registered at the lands registry. So we have to pay attention. Lands registry. You know, there's this trend now in Nigeria. They are adopting what the US have done. If you go to US now, all the whole 50 states, they have adopted geographic information system. Now we have it in Enugu. We have Enugu State Geographic Information System, NGIS. It is there in Abuja. Geographic Information System, AGIS. And some states has also adopted this geographic information system. It makes it seamless. You know, the world is developing and there is a huge invention going on in the technological space. So they need to accumulate all the data and make it seamless as possible. Now, I also mentioned governor's consent. I know that most of you might have not heard of it, but it is being commonly said. Acquisition of land is just like going to marry a woman. You can never get exhausted with the requirements. You can never finish it at once. Because this governor's consent has to do with what is called perfection of title or perfection of documents. You have your deed of assignment now from Powell. It is valid. It's your land. But do you know that you need to still perfect it? If you want to be more theoretical about this, you see that there are different stages and different obligations holders or buyers need to fulfill before they can actually say that, yes, I've acquired this portion or portions of land. But you need to apply for governor's consent because, mind you, every state now is now in the custody of the governor of each state as a trustee. So he needs to give his consent for any alienation done in his state, especially when that land even has your. But you know, in practice, it's not usually done. That's why I said if you go on the theoretical basis, the requirements are too much before you can say that your title documents are tight. But I'll implore you all to advise your clients and yourself to, even in as much as they are rigorous and they are many, and you might experience bureaucratic bottlenecks while trying to perfect your documents. But the ones you can do, do them. The ones you can do, really do them. Currently, in Nigeria now, if your clients or yourself do not pay the MBA remuneration account, it can be registered. They are on it. It's also one of the requirements. It has to be notarized to be tendered in court. There are just so many. So employ yourselves to just, the ones you can do, please do them. I said that currently in Nigeria, there's something called MBA remuneration. MBA remuneration. What it simply means is that if I buy land or you buy land currently in Nigeria, you are meant to pay 10% of the value of the land to MBA remuneration account. If you pay 10% to MBA remuneration account, your documents will be prepared by a lawyer and now tendered at the MBA's office where it will be sealed. Now you can take it to lands for registration and all that. It's what part of the things coming up now. and it's been enforced. Now let's go to deed of assignment. Deed of assignment transfers the assignors, that's like seller, the person that owns the land that is selling, the assignor's interests, rights, and ownership to the assignee. Have you wondered why just nobody can prepare a deed of assignment? I'll be more practical. One of us here came to me not quite long ago and told me, "Barrister, I need some draft that the person's brother acquired the property in the village, and that the person now speaking to me now wants to prepare deed of assignment for brother." It's wrong. Not just, you might prepare receipts, purchase receipts, but for deed of assignment, going by section 22 sub 1 paragraph D of the Legal Practitioners Act, it can only be prepared by a lawyer. So for people, because this happened to me, I experienced it not long ago. I know that some people might be doing it to avoid costs or whatever. It's wrong. Because what is being captured in the deed of assignment is the seller's or non-assignor's rights, ownership, and interest. That's what is now alienating to the buyer. So it's a serious business. It simply shows that in as much as there is no freehold, remember there's no freehold again, but now I'm assigning everything I have. If I have registered the land and it's 99 years they give me, and I've used maybe 10 years, remaining 89, or I've used 50 years, I've even used 5 years or whatever, I'm assigning the residue of that 10 remaining. If I have not registered at all, I'm giving it to you, but you know that you are still going to be confined. Whether your land is in the village, whether it's in town, the Land Use Act has made it so. Now we have survey plan. A surveyor prepares this to show the boundaries, dimensions, beacons, and coordinates of this land that you purchased. And this helps to prevent boundary disputes. And it's also very essential for CFO application and some other requirements that you want to do with your transactions you want to do with your land. They will usually request for your survey plan. Now also we have what is called a session and gazette. These are lands, the government or the state, let me narrow it down to the state governor of each state is a trustee. And know that the state governor is the government of the day. Himself and his cabinet, they are the government of the day. Their own lands, though as trustees. If they acquire a portion and tag it for overriding public interests, maybe for reserves or for parastatals or whatever, they can sometimes decide to give part of it back to private individuals. That's what is called a cession. So an accession is the document that shows that a formal land acquired by the government has now been released to people for private use. So the Gazette is an official publication, publication that acts or provides an official proof that the accession has been done. Now, Gazette does not just deal with accession; it deals with other government orders, and it's just a government publication, official publication of government. Also, we have deed of mortgage, and to be practical with this, I own a land. You have the money. I don't have the money at hand, and I need the money. I can come to you. See, I need this money. Can you lend me this money? I'm the borrower. If you give it to me, let me say 5 million naira. Give me this 5 million naira. I have a land worth that, or even more than that. I'm not going to run away with your money. You can simply enter into a deed of mortgage. It secures both the lender and the borrower. Because why it secures both the borrower is that usually, even though the person is now offering his or her property as a collateral, stricto sensu, by law, the borrower will still retain use and possession. You can still be in your house, even though you have mortgaged it to use it to collect loan, but you still be in your house enjoying your property, the use of your property. Unless the term expires and you didn't meet up, then the lender can now come up and take over the property. So you see that it's also a way where land can be transferred, deed of mortgage,